This is Antonio Gangale. Today I'll be discussing the federal case, United States of America versus Union Cheese Company. The case makes absolutely no sense. The federal court order for the injunction required that Union Cheese Company eliminate Listeria as well as other bacteria. The FDA had created in the mid-90s a policy of zero tolerance that dictated that Listeria be eliminated from the processing areas to prevent contamination from occurring. That sounds very good and all. However, on the same hand, federal law had the standards of identity of natural Swiss cheese in which you could use raw milk and age it 60 days. You'll see published paper, and this is in 1989. Surveys by the FDA have established that about 12% of raw milk is contaminated with Listeria. Listeria may be present in cheese factories where good sanitation and hygiene are practiced. There's also a published paper in 1991. Analysts of raw milk from the Midwest showed that 13% of the samples contained Listeria. It makes no sense that you would have a zero tolerance while the milk supply has a 10 to 13% probability of it being in there, as well as the law allows it to be raw. So you would be bringing in milk, and through the processes of that is how it kills it off. So it made no sense that there could be zero in your facility. However, the government insisted that there be zero, so that was causing enormous disputes with the Food and Drug Administration. And again, the government was fully aware that it was within the commercial milk supply. They're the ones doing the surveys. You also see in the case from their expert witness, dairy products are a major vehicle for the transmission of the organism. So within the trial record, you'll see even in the footnote of the judge that they're aware that it's in the commercial milk supply. So it's inconceivable how a judge would create a federal court order requiring Listeria be eliminated from the processing area. It just defies any logic. You'll further see in the order, it says anything that comes in contact with Listeria can be contaminated. So if you're bringing in milk and processing it, it affects where you're processing it. The order did not make any sense. Years later, that they will create the Listeria rule and say, well, after the lethality step. So it will take years for them to establish this policy. But in the meantime, they're blowing out manufacturers with this arbitrary policy that made no sense whatsoever. In Dairy Foods magazine, there's an article. It says, today it is known Listeria can be controlled but not eliminated in the dairy processing plants. So you have to wonder, the Administrative Procedures Act, if there was standards of identity and a law that was existing that it could be raw, and the government and the courts knew that it was in the commercial milk supply, why would they use some arbitrary policy that had no vetting, that had no Administrative Procedures Act of public comment or review or analysis? Why did they use some arbitrary policy while there was clear existing law that cheese could be made from unpasteurized milk? It could be made from raw milk. So how do you explain this federal court order? So I want the public to imagine that you have federal officials going into your facility multiple times, and one going on 3 weeks, where they're insisting that there be a zero tolerance while there's the commercial milk supply, that there's 13% in the commercial. They're testing raw inline products, raw silos, raw facility, environmental samples. The Fourth Amendment to the U.S. Constitution is the right of the people to be free from unreasonable searches and seizures. This protection ensures that we are free from arbitrary government intrusion. You see this inspection. During that period, the FDA began establishing mandates for the facility. And again, these were arbitrary. They weren't being uniformly applied through the industry. And it seemed to blatantly violate federal law. And their policies absolutely made no sense. We were a state-of-the-art facility. will later, a couple months later, be approved by the U.S. Department of Agriculture, which implies the quality of milk, the sanitation program, as well as the manner and method. We were heating the milk up to above pasteurization and had the whole times, as well as Swiss as a cooked curd. It was aged in a vacuum sealed bag, low pH, low moisture cheese, highly acidic. Again, we had a state-of-the-art facility, state-of-the-art CIP system, cleaning in place. Valves throughout the facility were torn apart and examined. It was on a routine basis, so any part of the facility, you could document what was cleaned, how. However, the FDA was openly and willfully ignoring their own final rulemaking standards of identity and seeming to arbitrarily create policy. And federal law was established in 1949. It was revisited in 87, and it's within the federal code in multiple places. So it was absolutely unreasonable of what the FDA was doing. It appeared to clearly violate the Fourth Amendment. Again, USDA surveys, they cover more than 100 items, including the milk supply, the plant facility, conditions of the equipment, sanitation practices, and the processing procedure. This inspection tells the plant manager about the quality of the material, sanitation, condition of the plant and equipment in the processing area. On December 14th, they were mandating numerous things. We had requested that there be some type of inspection order and some type of warrant. They initiated injunctive relief. John Marzilli states, "I have halted my efforts to achieve compliance voluntarily." So that's an interesting statement. What is the policy? And did that policy openly and willfully conflict with federal law at the time? Did the union have a right or privilege to make it in the method and manner that they were doing it? And was the FDA willfully disregarding that? Was there any rulemaking process to create this zero tolerance policy? Was there any public comment? Was it uniformly applied? Could it be applied? Is it virtually impossible to have zero at the whole facility? Listeria may be present in cheese factories where good sanitation and hygiene are practiced. There was a court-ordered search. Within the court filing, you'll see that here it states, the failure of FDA to find Listeria during the court-ordered May 1995 inspection does not convince the court that conditions have improved to prevent the presence of bacteria given its sporadic nature. The fact that Listeria strains other than Listeria mono were identified in recent as 19 indicates the union did not adequately sanitize to prevent the growth of bacteria within the Listeria genus, including Listeria mono. These samples were taken during the processing, so it's inconceivable how they expected to have a zero. And if you try to rationalize what the judge is stating in that, expecting to have zero bacteria during the processing, that's highly unusual even in the final product, not even considering the environment of the facility. So it's just absolutely inconceivable of these policies. Unlike sterilization, pasteurization is not intended to kill off all microorganisms in the food. Instead, it aims to reduce the number of viable pathogens so likely to cause disease. So is this court-ordered search, is it reasonable, and did the judge conclusions absolutely inconceivable? How do you rationalize it being in the commercial milk supply and having zero tolerance throughout the whole facility, considering all the laws and policies that were in place? Several footnotes within the court order. The video shows a facility with state-of-the-art equipment. Does it show the high temperature short time? Within these proceedings, the government insisted that it was unpasteurized. And if you examine the legal the definition of unpasteurized, did union exceed that definition? So that's, I believe, an important fact. Exhibit 1033 offered by union cheese. So it's clear that the federal judge knew that the raw milk in the Midwest showed that there was 13% of the samples of Listeria. So how did the federal judge create this zero tolerance when it's even within the footnote? You also see within the footnote of 8 regarding cheese samples. So throughout this whole entire inspection federal court ordered search. Did the FDA ever examine the blocks of the 200-pound blocks of cheese and do testing on that? And Union Cheese only manufactured Rhineless Swiss cheese. You also see in footnote number 9 regarding the USDA approval. So USDA approval demonstrates that another federal agency had approved us. Also, the U.S. Department of Agriculture actually physically inspects your equipment, unlike the FDA. They're also there present before operations, during cleaning. Additionally, the USDA inspectors are specialized within the dairy division. This particular one that was examining, I believe he grew up in the dairy and was a couple years from retirement. So years of knowledge go into his analysis. Additionally, the USDA approval came after the December 14th disputes. I believe it further creates issue that the U.S. Justice Department had two conflicting agencies, and one was going directly against federal law. So why it would take up a case and litigate and use taxpayers' dollars on policy that was never even formally established. So they appear to be going into federal court swearing that they would follow the law, and here they seem to be wanting to forge new law and have a federal judge create new policy, bypassing the Administrative Procedures Act in the rulemaking process was intended to do. You file a case regarding listeria, however, you seem to omit a process that kills off a 5-log reduction of microorganisms, that it would seem inconceivable that would not put that within their report. However, the FDA seems to omit this information. So I believe it really shows the distinction between what a USDA inspector and the FDA and their arbitrary conclusions of. Further, the USDA lists the improvement within their inspection report. I believe within the case, or that the FDA searched, that there was no improvements, which we can get into a lot of details of what Union was doing and had done, and the process. Further, you'll see in the USDA inspection policy that their policy during the inspection is taking a silo sample. The FDA seems to cherry pick producer lists or whatnot, which does not give any indication of what the actual milk quality is. Again, this federal court order, it makes absolutely no sense how the judge came to their findings of fact. How would you expect to have zero throughout the facility? If you're doing extensive testing, would you find tests within the milk corridors or where it's raw, within your pasteurized balance tank before it goes into the pasteurizer? There's numerous parts within the facility that it would be inconceivable that you don't eventually obtain a positive test of listeria. Most notably is that the FDA appears to have known that this order was virtually impossible. And you'll see within an affidavit of a third party, it says, during one phone conversation with Charles Sedgwick, he stated that it was going to be virtually impossible for Mr. Gangale to resume Swiss cheese operations. So with this court order, would it be cruel and unusual punishment? Can you create an order that's impossible? And is it uniformly applied throughout the industry? So is this order, is it impossible? Does it make no legal sense whatsoever? Additionally, if this order was violated, you could be found in civil or criminal contempt. Ultimately, we would go out of business rather than comply with the court order to rid our operations of dangerous bacteria. Again, you see that it's operations and not the actual product, and the laws will later be changed to after the final lethality process. There was a supplemental order within this case that we would sell the inventory and not comply. However, within that order, all the provisions of the June 16th shall remain full force and effect, except as expressly modified by the supplemental order. Does this order make any sense? Is there a Fourth Amendment right of reasonable search and seizures? And there's a case law in Weeks versus United States. The Fourth Amendment reaches all alike, whether convicted of crime or not, and the duty of giving it force and effect is obligatory on all entrusted with the enforcement of the laws. should find no sanction in the judgments of the courts which are charged at all time in support of the Constitution, which people of all conditions have the right to appeal for the maintenance of such fundamental right. The Fourth Amendment prohibits against unreasonable searches, protected against warrantless intrusions during civil as well as criminal investigations. The basic purpose of this amendment is to safeguard the privacy and the security of individuals against arbitrary intrusion of government officials. I'll further see that there was issues of improperly named parties in this action, and you'll see that it was within the record multiple times. In the United States, the right to receive notice before the government deprives an individual of a protected interest is guaranteed, along with the opportunity to be heard. Rule 65, with injunctions, a court may issue a preliminary injunction only on notice to the adverse party. The oaths of justices and judges. Each judge of the United States shall take the following oath. Do solemnly swear that I will administer justice without respect to persons, and do equal right to the poor and the rich, and that will faithfully and impartially discharge and perform all the duties incumbent upon me under the U.S. laws of the United States, so help me God. Representations to the court. So Rule 11, are there numerous issues? If this order is impossible, the U.S. attorneys that file them. So are there numerous legal issues within this case? And numerous individuals that would have had to sign off on this particular action. Finally, the most disturbing is in 2001, a federal judge permanently barred me from the use of the courts. Ultimately, I will be named as an interested party in 2006 when Guggisberg Cheese was filing a third-party motion to vacate. I believe that there's numerous legal issues, and I believe the order was impossible, so I believe that there was considerable issues within these filings with the court. Can you bar a United States citizen who's an interested party in an action access to the courts? Is it cruel and unusual punishment? Is impeding the use of the courts unconstitutional? I'd like to thank you for your time.